Hello and welcome to a new episode of Show Legal with Sagar Dutta. Firstly, thank you so much to all the audience for giving me support and love for the first episode. As per promise, today we are here with yet another episode. Today, I'm greatly honored and I'm grateful that I have this privilege to speak to none other than Justice Subrata Talukdar, who needs no introduction at all. In this Show Legal with Sagar Dutta, in this podcast, we get to learn the life and journeys of eminent legal jurists and legal minds. Today, I'm really excited to learn from Justice Subrata Talukdar. Sir, thank you so much for giving me this opportunity, sir.
Thank you, Sagar. Thank you to your team. Thank you for having me in this episode. It is really a privilege for me also to be part of this episode.
Thank you so much, sir. So, with your permission, if we can start with the... So, this won't be an interview. This will be like a conversation, sir.
Of course.
Should we start, sir?
I'm ready for a conversation.
Thank you, sir. Thank you. So, sir, I was researching and I got to know that you began your career in journalism. So, sir, writing for leading national dailies, how did that shape your perspective when you entered the legal practice?
That is an interesting question, Sagar. There was no conscious perspective as such, because when I was working as a journalist, I really did not have any idea that I would be landing up in the corridors of the Calcutta High Court. I never planned as such my entry into law. But as a journalist, I was writing for the Hindu and the Frontline, and it was quite an experience. And in the meantime, because of family pressure, I would say, I also did my law course from Delhi University. And after the law course got over, the family thought that I should join law in Calcutta. They spoke to my senior, and he also agreed. And I abruptly resigned from my position from the Hindu. And I still remember that I gave my letter of resignation to my chief editor, or he was the Hindu patriarch of the Hindu those days, Mr. G. Kasturi.
Right. Okay.
And Mr. Kasturi, the doyen who had come from then Madras, now Chennai, to Delhi, told me that, what do you propose to do? So I said, sir, I'm going to join law. And so he said, that may be a difficult proposition in the initial years. So you may consider keeping a lien with your job in the Hindu. See whether you can succeed in law for 1 or 2 years. And if you want to come back, you can come back. I had no idea that this would be the position. I just told him, sir, the two appear to be different fields altogether. So it is open to you to now accept my resignation. He did so the Hindu did so after a month, and I landed in Calcutta. But I would say one thing, yes, that in journalism you have to have a hang of the facts. And you have a length of story to which you have to write. The story has to be limited to so many words. So this gave me an idea. As far as drafting, in the initial years when in the seniors chamber I was being given drafts, how to put the facts together and how to draft a pleading. Of course, the legal requirement was completely different. Gradually one experienced it, but those inputs did help. And I was in the sub-editor's desk earlier in different newspapers, where one had to see mistakes in the copy and also give a headline to the story and keep the story within the printed format of the newspaper. All that helped later in correcting judgments, in correcting drafts. So I think unconsciously speaking or subconsciously speaking, the experience paid off in journalism when I walked into law. But there was no conscious perspective to it.
Right, sir.
Because as this, when I would like to quote somebody, an eminent person who says that life is what happens to you when you're busy planning other things.
Right.
So I was busy planning a career in journalism. I spent 7 years there. And at that moment, I never realized that ultimately I'd be landing up. In fact, just to summarize the situation, looking back, I was a student of 7 schools because my father was in the transferable job. The last being Don Bosco Park Circus. I was a student of 3 universities.
So, were you born in Kolkata?
I was born in Kolkata.
Right, sir.
Born in Kolkata and then went with my father. He was in the Indian Police Service and later he retired from Delhi. So then 3 universities after 7 schools. Calcutta University for graduation from Presidency College, then now Presidency University. Then Jadavpur University with international relations. And finally Delhi University, while I was doing my job as a journalist with the Hindu, to squeeze in time for the attendance. And finished my law from there. Then I did 4 stints as a journalist in 4 different newspapers. Then I went into practice at quite I would say an advanced age of 29 to 30 years, when people who had completed their law courses would have already had 4 or 5 years in practice. And then completed about 22 years in practice before I was given an offer to join the bench. So I had 10 years in the bench, so I joined it. Then I retired in 2023 July. And now I'm actually in an administrative capacity. So a varied situation, no doubt.
It's such a remarkable exposure you got. So many universities, schools. I think this is really remarkable, sir. Really remarkable. So after, like, when you officially joined legal practice, after that you never gone back to journalism.
Sagar, but to be very candid, the initial years were whatever happens to every junior. There is, as you use the word, formative years. The formative years are largely years when you are forgotten as a person in court. I wore my gown in January 1990, and my senior was introducing me to the court. So you had the role was to be behind your senior, to watch courts, to watch mentioning. So those formative years, each year, each month could have been painful.
Right, sir.
And particularly for someone who had come at the age of 29, 30 and was used to a salary, But, well, as destiny would have it, that things worked out. Gradually, my senior, Justice Ashok Kumar Ganguly,
Okay, sir.
his chamber was in Khidirpur at that time. I had a motorcycle with me. I used to go in the evenings to his chamber, park the motorcycle.
So you used to go from this house?
No, my wife is a banker.
Okay, sir.
Or was a banker. She has retired. So she was allotted quarters in Entelli area.
Achha, right, sir.
So I used to travel from the bank's quarters on my motorcycle to the senior, and the senior would give me tasks. We were about a group of at least 5 juniors seated on the same table across each other. So at that time, the chambers looked very, very formidable to me. Very little work was done then on laptops or computers or on. So mostly we had to consult the big books.
Right.
The AIR and SCC was not so common then.
Right.
So in Bengali, as they say, the senior used to tell me, if I quote in Bengali, "Poro,
Absolutely, yes.
aro porashona koro, aro porashona kora lagbe." So went on
Right, sir.
reading. and no work practically, because unless and until you're prepared for work. But what happened then, I think, also shaped me up. Whenever I got, because that is the time when you get to read.
Right.
As a junior, to all juniors, I like to send this message across that exactly the time when you're in the profession in the beginning and you do not have much briefs and you want briefs, the time you have to read then will not come back to you. So what I used to do is that my seniors was largely a constitutional writ chamber. So I read up books whenever I was there in the chamber available on the constitution and other related. That helped a lot in my subsequent. But subsequently, it was easier for me to write whatever he had to. Those were the formative years.
So that time you were married?
I was.
Yes, sir.
I was married for at least, by that time, 4 years.
Right, sir.
And then during my earlier junior stages, in 92, I was also a father.
Oh.
After being married for about 6 years. So, but one had to get along.
Right, sir. So, but as per the culture, like in the initial days, we don't get paid. There is no income. So, wasn't that difficult for you, sir, in the initial days?
Of course, it's a difficulty for everybody.
Right, sir.
And those days were definitely things were cheaper than they are now.
Right, sir.
But law is a profession where work is not given unless you're prepared for that work. So for that preparation, you need an environment, as particularly a place where you can learn. And of course, you need a kind of a mentor who helps you to learn. It may be in the form of a senior, chamber senior, or it may be in the form of anybody who is senior to you, like an elder brother. Yeah, to that extent, my senior basically insisted that I grasp the basics of whatever his chamber work was doing. And then, of course, he gave me drafting to do, and the drafting was by hand because we did not have a typist to share among so many people, a single typist. So, and here I will mention another name, of course, Mr. Milan Mukherjee, who is a senior advocate, was then staying in Salt Lake. And he used to call me over, although I was not attached to his chamber, and give me some briefs to write, such as a bail application or a anticipatory bail or an anti-bail application. And then I learned some money out of it. And then he was to pick me and my wife from my home at Salt Lake and drop her at her office. It was then at Droid Street, on way to Park Street, on way to High Court. So all these things now I understand mattered quite a lot in keeping my morale. And my uncle who brought me into this profession, he is a retired judge, Justice Subrata Talukdar.
Okay, sir.
He also interacted with me because he and my father decided that I should leave journalism and settle down into law, because this has been I unwittingly then I became a third generation lawyer. My grandfather was a judge.
Okay, sir.
My uncle, who died quite young, relatively young, in 1998, Mr. Hon'ble Talukdar, was a leading criminal lawyer. My other uncle, I have just told you, was a service judge who retired as High Court judge. So without being prepared for all this, I became again a member of the family who would carry this flag forward, if I may say.
Right, sir.
So this happened, just people chose it, and now long years have passed by.
Right.
And I could not go back into journalism because that would have caused an embarrassment to me that I'll be called a failure in law.
Sir, how was your law school, sir? Like, how was your law college? What was the teaching?
Law college, Sagar, my experience was limited to just attending classes.
Okay.
Because I was in a regular course in Delhi University, evening law course.
Right.
So I used to rush from office so that I could give my attendance. and take time off, because even as a journalist we used to write our copies in the evening. But my office knew about it, and my chief reporter, a fantastic gentleman, he's no more there, God bless his soul, Mr. N.K. Doval, he used to say कि बंगाली बाबू तो यहाँ नहीं रहेगा, ये तो जाके law practice करेगा, because Bengalis were associated with law, legal practice. So his opinion was something like that. And well, I gave the examinations and got the degree. And law, of course, that was what mattered.
Right, sir. So you just mentioned that 5 to 6 of you, the juniors, were used to be in your seniors' chamber.
Yes.
So, sir, if you can, in some more detail, if you can bring back the memories of that initial days, like the formative initial day when you started the practice, like first 6 months, 1 year, how was it? How you prepared yourself? How?
Like those days, as seniors chamber was, I would say, akin to being in what they say in ancient times, being in a gurukul.
Achha.
That kind of, I would use that expression, a gurukul culture.
Right, sir.
The guru was, and his ambience that was set in his chamber had to matter. So after court is over, if you had to be within the chamber within a particular time. In the chamber, it was like a classroom when the guru was there. And you had to do your work. Whether if you had no work, you could not just have an idle chatter or anything.
Right.
And the best time for all of us was when our senior used to go out for his conferences.
Right.
He had a lot of conferences, so when he used to go out we felt free. But then those are the days when all of us were actually sailing in the same boat. Some a little more senior than us. So we had our different designated cases, who was to handle what. And there were 2 clerks and 1 junior typist. So you had to manage time and responsibility. And the senior would just expect that you deliver the result. Because if a matter was given to you, you had to write it by hand, get it typed out. And those days, the courts were the writ courts, the constitutional courts, did not have specific jurisdictions as they have today.
Right.
Like today, we have split into education, transport, land. Whether you could move a matter in any writ court.
Right.
So you had to get your matter ready. We had to, in Bengali we say, juto shelai to chundi part. We had to learn that. We had to even learn how to stitch a copy, how to paginate the annexures. So all the responsibility was there along with the clerk. The senior had to be handed over the brief, and we could move an unlisted motion.
Right, sir.
And whenever I got a brief of my own, I was very excited, because that meant a little money on my own,
Right, sir.
minus expenses. So as to go and tell my senior that this brief I have got. That was after I had completed about 2 years with him. So I still remember the man wanted to get a regular job in a college. He was a college gardener in a college. That was Barashat Evening College.
Was this your first case?
That was one of my first cases. There are 2 first cases, if I may remember.
Yes.
That was one, and there was another about a service matter of 2 employees in the West Bengal State Electricity Board then. So I used to go to my senior and tell him I've been briefed, and your fees I cannot afford with the kind of money that gentleman is offering, but should I or should I? So he would nod gravely and say, yes, you can. And then that gave a real sense of satisfaction. I'm going to present myself in court. Then there was another time when those days, being a senior mattered. Suppose a junior was there in court to mention a matter, and he looked behind him, and he has been waiting in court from writes at 10 o'clock because he wants to mention. A mentioning is you bring it to the notice of the honorable judge. And although he is there from 10 o'clock and the court gets crowded and he looks behind him and he finds 2 or 3 seniors, he has to vacate the space so that the seniors get that space. So his entire waiting period gets nullified in a single, that kind of a culture was followed in those days. So I remember that I wanted to move a motion of my own before Justice, a very aristocratic judge in our days, Justice N.K. Mitra, in court number 8. He was sitting in single. And you had to move a motion, and it was an unlisted motion. You could hand it over to court would consider it and pass interim orders. So I did not get my chance for 2 days, 3 days. And court number 8, as you enter, there's a long table facing the judge where the advocates sit down. So I stood for 4 days in the corner where the judge's corridor begins, just to draw the attention maybe of the judge, because I was not getting my chance and puja holidays were coming and I would lose a brief and the fees. And I think the judge, honorable judge, noticed me on the 3rd or 4th day that this boy is standing there, and he ultimately asked me, "What do you want?" I said, "Lordship, I have a motion." He said, "Very well, I shall, before I rise, I shall hear you and then rise." I was satisfied. My job was done. So these are the issues which face every junior.
Right.
And I was also part of it.
Sir, so staying in a chamber under the guidance of your senior and then independently practicing, was there like a formal move or like how was the transition, sir?
The transition was very sudden because my senior was expecting to become a judge for quite some days.
Okay, sir.
And the formal announcement was not coming.
Okay.
So it was, I think, in 1994 when I was in Delhi for a trip to Rajasthan with my parents. The families were traveling. And then I got the news that my senior had become a judge.
Right.
So I came and the juniors had to select their options. So I then decided to not join any other senior, but asked my senior's permission, and with the limited briefs that I had handled in his chamber, the wakalatnamas that I had signed, which I could call my briefs, I set up my practice in this chamber with 3 books, 3 bound books, 1 civil procedure code, 1 criminal major acts evidence, IPC, and criminal, and 1 constitution. They were bound and they had, I remember, some pages in between for making notes. Those 3 books and those odd number of briefs and 1 landline here. My uncle was also practicing in this chamber on the other side. Now he is no more there. So the landline used to ring whenever clients wanted to say something. And I was behaving like a fierce guard dog. Like I used to protect my clients, like when my uncle used to say, so a professional should not talk so much. But I was very keen that my clients should know the full aspects of whatever is happening in their case. And that they should. So there are 2 things here I would like to convey again to the junior practitioners. Anytime we begin life as a lawyer, our clients are limited. So I would always tell a junior that this is a profession where your name grows by word of mouth. People, like a doctor, say he's a good lawyer, he's a trustworthy lawyer. So that is one aspect. And the first conference for a junior with his client must be an elaborate one. Whether it be in the chamber or in the high court, it must be substantive. You must get to know the client and the client must get to know you. So then confidence emerges. After that, when the matter is taking time in the high court, it's on affidavits, and then final hearing. Even if you meet your client for a brief period of time in the court corridors, it would not matter. Because you already in the first conference, I would never say hurry up the first conference. Give it time, understand his particular situation. Suppose it is a service matter. He has come for some relief in monetary terms. There must be an environment around his problem.
Right, sir.
Maybe not a personal environment, maybe a office environment, something happening with his past years in that particular organization. You must get to know every aspect. The pulse of the situation must be felt by you. And even the client then understand that I'm in the hands of a lawyer who understands me. So my reading of legal success is not how many cases you won or how many cases you lost. Winning or losing is always there. But the client also does not expect that you always win. Client expects integrity, which is natural to anybody who is winning, who has. And secondly, reliability, that I'm in safe hands. You may be extremely knowledgeable, you may be extremely articulate, but question is, if clients don't believe in you and change lawyers frequently because of that, that is a marking which is not suitable to a good legal practice. So therefore, and then there are very other good habits to be followed in law. Clients may always want to change from one lawyer to another. This is something which in Calcutta, I've heard it is quite endemic. So if the lawyer to whom the change is coming, he must be in a position to interact with the person. What is the reason? Why is the client coming to you? He may give his opinion. A junior's brief may be going to a senior. Senior must make that extra effort to find out.
Right, sir. So as you mentioned about senior advocate Milan Mukherjee, so like that, any initial day associations you had, still now you have a great relationship with, like, if you can name few.
There was a very senior advocate in constitutional law was Mr. Shomaraditya Pal.
Right, sir.
And actually Mr. Pal taught me, I would say, in one case that I had the opportunity, the good fortune to work with him. There was a disinvestment of a public company called Judicial. So we briefed Mr. Pal. It was my chamber brief. I was an appellate side practitioner, therefore I had my own briefs. And every day after court ended, he would just write in his diary, Judicial, 6 p.m. or 7 p.m. or Subrata, 6 p.m. or 7, which means after court, you have to go to his...
Right.
The matter went on. Interestingly, when the matter came to me, the Officers Association had come challenging the disinvestment process. Jessup and two other companies, if I remember. Braithwaite was one, and Jessup was the other. So at that time, the government policy was to disinvest into private hands. The Officers Association was not in favor of disinvestment. So the clients had come, and I was not physically and mentally in a mood to sit down in a conference with them. So I said, I'll meet them later. So this is also important in law, that you have a good chamber clerk.
Right, sir.
A clerk who manages your chamber like it is his own.
Right, sir.
Or his own well-being depends on it. I had an in-house clerk, senior experience. After my uncle, as I said, died, he joined my chambers. So with him, my passage in High Court was easy. He was elder to me also. And he met the clients and he told them that that was a weekend. He says, you come on Monday. Then to court. On Monday they came. I still remember after I had seen the papers, understood the papers, he took me to court number 19, The air conditioning was working, and the judge was not sitting in the second half.
Okay, sir.
He brought a typist from the High Court, and he told me, you give a dictation now. So I gave that dictation sitting because he told me to give it. I was not feeling well. I was running a temperature maybe. He says, you give a dictation and leave the rest to me. Sagar, this is what happens. Your opportunity knocks and you have to understand that this is the opportunity. I did not, my clerk did. That matter went on for 6 years. Mr. Shomaraditya Pal led me before the single bench where we won, before the division bench of the Chief Justice where we lost, and then before the Supreme Court I was led by Mr. Dipankar Gupta, the late Solicitor General of India.
Right.
So up from 2002 to 2007-8, that single matter straddled 3 courts. And you see what happened when you do these kinds of matters without realizing. The court also gets involved in the subject.
Right.
So before the single bench, we were allotted time. That after the second half, I shall hear you. So entire court, people used to say, what is happening in court number 8? Oh, nothing is happening today. Subrata Das matter is happening.
Right.
So your name unwittingly goes around the corridors. This is the kind of opportunity which my clerk understood that this matter may carry, and he made me draft it. So we did paper books, we did 3 matters together, we went up to the Supreme Court. We not only earned money, but we also earned a lot of name and the opportunity, as I was saying, of working with Mr. Pal. I still remember Mr. Pal, we had our designated seats in his chamber. He is not there, God bless his soul. And the client used to sit in their chairs, and me and my junior used to sit with our bundle of books and files on the left-hand side. And he would converse on a particular subject, on a topic as far as the brief is concerned, with any one of us. And that conversation, you have to just remain and hear the conversation. And I still remember, it's like the way he handled a writ petition was like you peel an onion or you peel an orange. There was a letter, if I remember correctly, of just 15 lines, dated 7th March, even if I remember the date currently, 2002. And that letter was an annexure to that paper book. And before the single bench, that letter caught Mr. Pal's attention. And Sagar, you believe me, that for 7 days, the conference only revolved on that letter. So that 15 lines, every comma, every full stop, and of course, the court also was taken through that letter. And interestingly, Mr. Pal went to Delhi for briefing Mr. Dipankar Gupta. And Mr. Dipankar Gupta was Mr. Pal's senior in the profession. So this is how it happens. I'm absolutely surprised that it happened with me, but I'm definitely benefited from this experience.
So who has been your role model? So if you can...
To specify, every individual had his own pluses and minuses. So to that extent, to have a role model for all the aspects of a particular personality is difficult. Definitely, I remember Mr. Pal for his very intensive and exhaustive work on briefs. And it is not that I have not seen him, at least during those years. I also worked with him in a few other briefs, that he would divert his attention by taking other matters. If he was focused and he was on the subject, so that is where then I have worked with other leading personalities also. In fact, I have a sense of being overwhelmed today at this podcast because the episode 1 was of Mr. Anindo Mitro, and his shoes are so big that I cannot fill it really. But he is also very much a respected senior of my Presidency College, now university, member of the Alumni Association. So I'm so what would I say, with a sense of overwhelmingness, I am saying, Sagar, that you selected me for this episode too. But,
I am grateful.
well, I can talk about my experiences. So Mr. Paul was one of the persons. And then when we became, when I became a state government advocate, at that time also, the exposure was of a different nature. So I still...
If you can elaborate the experience.
That is one interesting aspect. I would, as a state government advocate, I would definitely mention the then government leader, Mr. Ashok Banerjee. Mr. Ashok Banerjee belongs to his father was one of the most renowned civil lawyers of Calcutta, Mr. Ranjit Banerjee. And they have their old house in Bali. And Mr. Ashok Banerjee was at that time 2011 when this government came and he became the first government leader. He threw himself into the task of defending the government, and actually that time I would also mention Mr. Kollan Banerjee, a very senior lawyer, who insisted that I join the government plan because the government needed to be defended. And it had to be defended on different fronts. Health was an issue, the police administration was an issue, education was an issue. So everywhere there were batteries of lawyers who were seeking explanation. So Mr. Banerjee really gave me a lot of exposure, my government leader. Then another very gentleman who belongs to the same district as my grandfather, Borishal in Bangladesh, Mr. Bimal Chatterjee. His is a legendary chamber. His chamber has produced high court judges, chief justices, and I had the good fortune of working with him in a few matters. So you would excuse me, Sagar, if I am talking a bit too beyond my brief.
Absolutely, sir.
But then now that we have entered into this conversation, so I remember going to Mr. Chatterjee's chamber with a plaint on the original side.
Okay, sir.
So that was a brief, which was my brief. So he could afford Mr. Chatterjee, so I thought I'll write a plaint. But writing a plaint and writing a writ petition are two different ball games altogether. So I remember I entered his chamber at about 10 or 11.
So what was your age?
That was in maybe 95, 96. I was born in 61. So 91, I was 30.
So around 2-3 years of your practice?
Around 4 or 5 years.
Okay.
After I had started my practice in Salt Lake, my senior became a judge in 94. I started in 94 here. So naturally, I was very keen to keep my client. So I went to him and he could afford him. So I entered Mr. Chatterjee's chamber at about 11 in the morning. It was in Broad Street, and I parked my motorcycle, got into the chamber. He called me, saw the plaint and said, called his clerk, I think his clerk's name was Uttam, and told him, ask him to sit inside where the juniors are and give him some paper to write. So I went inside with the paper and was to rewrite the plaint. And I stayed there till 8 in the evening. Mr. Chatterjee went up for lunch, came down, went up for tea, came down, called me thrice nothing happened. My plaint was equally miserable. So he says, this is not done, I'll write it for you. But now, then opened his drawer. At that time, my daughter was born in 92. She's practicing law in England, and my son-in-law is also practicing law there. She's doing her intellectual property and my son-in-law is in admiralty law.
Right.
So she was 92. She was about 2 years of age. My son is he's a criminal lawyer now. So he was born in 94, so he was about 1 year of age. So Mr. Chatterjee gave me 2 chocolates. Says, give that to your children and go back home. So at about 9 in the night, totally, you would say with a sense of complete defeat thing, but the last gesture, the 2 chocolates that he gave to my children.
Nice.
And later on, during my years as a state government advocate, he was my advocate general. And I went to ask him because when my judgeship came, he was the Advocate General or my Advocate General. So I went to his Advocate General's chamber and I told him, sir, this is it. So he knew about it. He said, do you want to? Because if you want to, then you have to remain mentally active. His purpose was that. But as a lawyer, you remain mentally active. As a judge, also, you have to. You see, if you and I was mentally active because lawyers. I loved interacting with lawyers because you do not know everything. They also teach you a lot of things. So I told him, sir, I will be having a stint of about 10 years. So because of this 10-year stint, I would like to try it. So then he said, okay, fine. Then you.
Right, sir.
So this is one experience. Mr. Shaktinath Mukherjee,
Yes, sir.
he is a legend. And in my small capacity, I had the opportunity to also hear him as a senior counsel and pass judgments. So of course, he had the rare aristocracy about him. Go to Uttarpada.
Can please share some experience?
Yes. Mr. Mukherjee's chamber going from Salt Lake to Uttarpada means that particular Saturday or Sunday, because he used to consult on Saturdays and Sundays. Weekdays, consultations were not open. So means that you are prepared, that the whole day you are there. Because he may call you at 12 o'clock. But clients are sitting in his chamber from 7 in the morning. And his clerk, Mr. Bachada, Bachada would knew that AIR 1964, this is the page number. Yes, and Sir would only tell him that this is the page number. But given the stature of the person, Mr. Shaktinath Mukherjee, the way he handled the juniors and the clients, never getting offended at whatever mistake you make. Because as juniors, we have a tendency to prove ourselves. So if you're sitting with the conference, you want to prove that I've read this point, I've said this point. He was extremely, even if that proof did not match what was part of the case, he would be very patient.
Right.
Another gentleman with whom I had great regard and I worked was Mr. Kashikanto Moitro,
right,
who is no more there. I've never seen a person so full of a dignified approach. The junior most person, he will call him Apni and make him sit. And Kashikanto Moitro used to take patient notes. He had a notebook. So he'll sit, and when the conference starts, he will make notes. And his clerk, I forget his name, would keep. So I, as a junior, used to see at what page my note is there. Because when he was arguing, normally juniors have to sit next to the senior counsel and be there. But with Mr. Moitro, one could not take a chance. If because of the fan, the page number of the notebook was not matching, then you would be finding yourself arguing some other matter.
Right.
So you have to keep to the particular page number in the notebook.
Right.
That sir is opening that. But his English, his approach to court is very classical, very old style. Those actually, whatever that's what I said in my farewell address.
Yes, sir.
I think you have
Yes, sir, yes.
You wanted to ask me also
Yes,
on
sir.
that subject. That I mentioned that in a courtroom, what catches the attention of the judge. I think today's juniors would.
Sir, I remember you mentioned the bar as a judge mirror.
Yes. Judge mirror, and the whole thing is maybe I do not want to be sounding pontifical but then I do feel that a judge is interested in a very good conversation, and the junior who can hold the judge's attention with that kind of conversation from the facts of the case, because the judge is also wanting to do his job.
Right, sir.
He wants to also either give relief, and basically most judges, and I have, would like to extend a relief. But the junior has to make out a room for a conversation. And that conversation, that sense of conversation, comes if you're thoroughly prepared and you are actually so much into the brief that you use the word I always while arguing. You do not say my client is happening. You say I'm in a mess. I have been wronged. So that, and the judge immediately understands that this boy knows the subject matter, and it will be good to hear him. And after all, judge is also a human being.
So as you mentioned, when you were presenting the plaint before Bimal Chatterjee, you were finding it difficult and maybe there were some flaws in the plaint. But sir, from that day till you become the judge, how you will advise legal professionals, young professionals like me who had just joined the profession, like how we will actually grasp the matter and what is the process?
First things first, I would just, this question is, the client would normally come with a bundle of papers.
Okay, sir.
And now, of course, they might show you on a laptop, on a tablet or whatever. Right. But during our days, the client would come with a bundle of papers. Right. So you have to first sit down with him and take a note. Right. It's the doctor's preliminary diagnosis, which you do before you meet the real doctor, his junior. So from the note, you get a sense of what is his issues. Then the first thing, which I think it is from basically the English practice, which we see barristers follow it, but this is very important. First thing first is you sort out the papers. You take the papers chronologically. The papers which matter, you keep them one way. Papers which are secondary, you separate, as they say, the grain from the chaff. That is the first job. After you have the papers chronologically, you write out a list of facts and events. This, on the appellate side where I practice, this was not the normal junior's approach. Right. The approach was, very well, start writing the brief.
Thank you, sir. Thank you, sir.
The brief has come, have a conversation with the client and start writing the brief. But I think this whole this exercise, which they say in the barristers, the painting list of dates with facts and matching the papers which are relevant with that list of dates. You have the brief under your control once you have written something with your own hand. And after that, you can converse on the facts itself. And after the facts, you look for the law. So you just don't begin with the law, because I believe is what Sir Rashbihari Ghosh said, that I do not know the whole law, but I know where to look for it.
Right, sir.
So one of the big things is how you research it. And as you have a question that what is the ratio of a judgment? That will always be relevant to the facts which you are handling. Right. And the judgments may have several principles. These are many of the judgments which we read run into hundreds of pages. So exactly what you're looking for is what is matching to your facts. The anecdotal that I had gone to Delhi for a matter, and one of my juniors, a lady, I sent her to a senior advocate, that since I will not be there to handle the brief, you please brief him, and I requested the senior advocate. So he asked her, what do you think is the ratio of one particular judgment? And she quite innocently answered 50-50. So later on, so I asked her, how did the conversation go? So she told me that she answered, I showed him the judgment which had brought out. So he asked me, what is the ratio? So I said 50-50. I said, very good. She must have thought that I'm not teaching you anything. But that is what the ratio may be different for the entire judgment. But what is important is every judgment stands on its own facts. So it is after only you know your facts well that you can apply the law to those facts. It's not a difficult exercise, but the initial years you have to put in a very painstaking labor. And the time is there with you because you're not flooded with briefs or you're not pressurized. And so juniors told me that lawyers earn very good fees everywhere, where they are successful. So I was going for a conference in Delhi with a junior who is at that time now a senior, of course, in their matter. So he said, sir, if you are a successful lawyer, money should not bother you. Money would have to follow merit wherever it goes. And there is an element of luck, Sagar, also, where 5 to 7 years in the profession, you must be able to judge whether you may be very well prepared for the profession, but the profession may not be giving you back what you need. That after 5 to 7 years, then you look for a different way to handle the profession.
Right, sir. So what will be your suggestion to improve on drafting? Like, drafting is most important and crucial aspect.
Drafting is there was a draft where the matter was dismissed for default.
Okay, sir.
And I was told by the junior that the briefing advocate, he should write a recalling application. So the junior wrote a 3 to 4 pages recalling application. That the dismissal for default was, as we say, is not due to our fault. But when you talk about drafting, when it went to the solicitor or the advocate briefing us, he says, such a short recalling application, you cannot command fees on that.
Right, sir.
So we had to put in, or rather we had to put in the whole story, and the actual story was in the last 3 pages before the prayer. Drafting this is somewhere I would like to really make a comment. You see, our knowledge of English does not necessarily mean we are all good draftsmen, because English is not the only criteria. Law, as Somerset Maugham, the famous literature, said, every word has a content, a meaning. Law, every comma and full stop would matter. Drafting, the first stage is if you know your facts, as I put it earlier, with your list of dates and facts, is when you can really draft. First finish the factual drafting. And after you finish the factual drafting, you can get into the legal aspects of the matter, take an opinion, take a counsel, read the law and then apply. But it is, initial years I think I would suggest the basic part, juniors, if they have time, to do it the old way. Write it by hand or type it out themselves instead of dictating.
Yes, sir. So now if you have broadly described about your initial days, the formative years. So if you can tell us now the transition from being an advocate now to a judge. What was the transition? What was the first reaction when you got the news? Something related to being judge.
The first reaction I would justifiably say was one of gratitude, elation.
Right, sir.
In Bengal, still, we associate a lot of. We treat the judge's office as really a high office,
right,
and we have in Bengal throughout that. And as a middle class Bengali, both me and my family, we were happy that the offer of judgeship had come, and had come at a time when at least I could spend nearly 10 years in the bench. The question of transition as a junior judge on the bench, one understandably felt nervous, because it's a different atmosphere altogether when you're on the other side and sitting with a senior judge who has spent long years and has developed a formidable reputation, whoever I sat with several. But once that nervousness wears off And I must say, as far as advocates is concerned, they're extremely supportive. I have, the transition only to that extent was, you see, the advocates, I've always had a very positive attitude towards the bar because I was a member of the bar for so long. So one has to, and the bar also reciprocates that sentiment. That for them, they can read whether this judge is relief-minded, whether he is patient, whether he can think. So the transition, there were no major issues really, excepting that the initial months, the first few months, and one particularly the difficult part is when you have to pronounce an order in open court in full view of everybody. So I had a difficulty in, I could write the orders or pronounce them or dictate them in the confines of my chamber, but pronouncing an order in open court was a different experience altogether because one is extremely conscious that how is the order being accepted by the advocates, what are the mistakes in that order, how is the senior judge reacting to it. But after that, as a senior judge, I have had the good fortune of sitting with several members on the bench who began their judicial innings on the bench with me. So we have had a very reciprocal relationship. I have encouraged and I had always said that your first order, whenever you dictate with me in court, please take the printout of the order and bind it and keep it because it will remind you of your first order. So that much of, if you can say that kind of a transition, it was not a very painful one,
Right.
but initial years had those.
So if you can share some memories and some specific important moments of your life as a judge.
You see, all the moments required your full attention. And I'm grateful to God that in many instances that He has been able to guide me correctly because once you sit on that chair, I think the transformation is natural. You feel that you have to do your best, do your work and do your best. Some memories, well, to start with, you see, these days, I'll come to that later. There's a lot of media reporting. The judge we are on YouTube also.
Nice.
But see, one of the memories I have, and these memories may not be interrelated to each other strictly, may not be strictly judicial in nature, but the memories from a courtroom. I was in 2018. I was hearing in the single bench the panchayat elections, issues connected to the panchayat elections to be held in Bengal.
Okay.
The matter had come on remand from the Supreme Court with a directive that the High Court should hear it. So since I was holding that jurisdiction, Panchayat Group 5 jurisdiction, the matter came to me. The High Court judges were not sitting then because the bar was on some kind of refrain from work resolution. So my court was, the advocates were not appearing, but the clients were appearing and they were all representing different political parties because the panchayat election and the election commission was being represented, the state election commission. So I had requested the parties to address the court in English and also had allotted time for the interesting part was from the side of the Congress. Mr. Audhi Chaudhary was given time to make closing arguments. And I tell you, Sagar, I requested Mr. Chaudhary, I'm not saying this because of a fascination for any particular individual, entity, etc. I'm saying this purely as a matter of experience in a courtroom. Please, I should be understood correctly. Mr. Kullan Banerjee was there for the Trinamool Congress, with Adit Chaudhary for the Congress, Mr. Robin Dev for the left, the Bharatiya Janata. So these are political parties who had a stake in the Panchayat election and wanted to tell court about the reliefs they wanted, the problems they faced. So closing arguments were meant for Mr. Adit Chaudhary. I requested him to speak in English, and I think I gave him 20 minutes. Let me tell you, there was pin drop silence in court. When he spoke, it was the oratory, if I may use the word, was of the highest category, and in English. And two of his advocates were behind him, but he did not take help. He had a piece of paper. You could hear a pin if it fell on the court. So I complimented Mr. Chaudhary for this kind of spellbound. Even as an honorable judge, I had to wait to take notes. He spoke so well and spoke so demandingly. In fact, Mr. Kullan Banerjee, gracious of him, he was on the opposing side. He told us, the court and those assembled in court, that Mr. Adit Chaudhary was a leading parliamentarian. And when they had joined parliament, the younger group, and from him, many of them had learned about how to conduct themselves in parliament. So this is one of the takeaways. That the other interesting part was, I was sitting with a senior honorable judge, and when I had just joined practice, and there was a matter where a person was supplying textbooks to schools in West Bengal and had not been paid. So he wanted his payment. So the senior honorable judge, he wanted an injunction, or he wanted an interim relief. He wanted that the state should first pay and then he will begin his supply. But the injunction was granted against him by, of course, my honorable senior judge. So after we exited the courtroom, I asked him, sir, but so much of money is outstanding. So he told me, whenever you feel in doubt that there is a balance in these cases, that somebody could get an order, but you are not giving, go back to the first principles. The first principles of an injunction, we all know: prima facie case, irreparable injury, balance of convenience. So he asked me, what is the balance of convenience? If any interim relief was granted in the publisher's favor, do you realize that students all over the state will not be able to pursue their classwork? They will not have books. Where is the balance? Balance lies with the student than with the publisher as of now. So therefore, we denied him the injunction. We kept it for further consideration. So but the balance was with the students, who had to continue with their studies, could not lose an academic year, because the publisher cannot stop supplying books. This is another takeaway.
Right.
A third interesting thing happened. A gentleman was arguing in person, and he had been arguing in court, in several courts in our high courts. So he was arguing in favor of a patent to be declared in his favor. So there were 3 appeals. And those 3 appeals, he had won. He had won injunctions before the court at Alipur, and the manufacturers of those items who were resisting the patents, they had moved court in 3 appeals. So the gentleman was a lawyer and also arguing in person. So when he came before our division bench, I found that in one of the appeals, one of my chamber juniors was appearing. So I gave him an option that, look here, I can retire from the brief, because this gentleman had built a kind of a negative image of himself before other courts, and in several ways. I need not dilate on that. But I gave him that option that, do you think I should retire from the brief? Because my chamber junior is appearing in one of the appeals. He thought and he said, yes, my lord, you may retire. Then I told him that, look here, there are 3 appeals on the same issue by 3 different sets of manufacturers. If my chamber junior is there in all 3 appeals, then I'll retire. But if he's there in 1 out of the 3 appeals, I will not retire. So it so happened he was in 1 of the 3 appeals, so I did not retire. Now this gentleman, during the course of hearing, we asked him to argue on merits. He did several things which were not proper for a court proceeding. He made wild allegations against the senior counsel for the other side. He also made wild allegations against conduct of certain advocates. So this made the bench feel frustrated. So we issued a rule of contempt against him after getting reports from the Bar Council. So he tried to evade the contempt. He went up to the Honorable Supreme Court, got an interim relief. But ultimately we could nail him on the contempt. And he went behind bars for 15 days before he could go to the Supreme Court again and get relief from our order of contempt. So once he came back to our courts, this time all the preliminary issues, his waywardness, or what if I would say so, the contempt, those were all past. Now his main appeal was on merits, to be heard out by, was before us. So again I asked him, and I was sitting with another honorable judge. So I asked him that now that he have suffered whatever, we knew the background, he has suffered the contempt, would you like to argue the appeal on merits before us? Because he may have a feeling that we have punished him for contempt. So he said yes. And interestingly, Sagar, not only he said yes, he argued and he won. The ultimate decision was in his favor. Of course, that speaks for how courts ought to function. And not that we did something extraordinary. We did something which you're saying is natural to courts. His punishment was immaterial. That was past, because now he was on merits. I remember now he's a sitting judge of this court. I'll not take names, of course. So during his acceptance speech, and he's a fairly senior judge, honorable judge now, his father was a judge. And in his acceptance, his father was a judge of the district judiciary. And his father had an issue with the High Court, or the High Court had an issue with the father for considering his service conditions or service issues. But those service issues, for that his father had come to the High Court on the judicial side, because administrative side the issues had to be resolved on the judicial side. And the High Court corrected its order on the administrative side. So this honorable judge, who is now a sitting judge, said that I have accepted the judgeship. I wanted to come to an institution which, as it happened in the case of my father, could correct its own mistakes. It was beautifully spoken. It could correct its own mistakes. And therefore, I wanted to be part of this institution. These are some good takeaways. We are really, as far as this whole court system is concerned, there is no intellectual inferior or superior. Just because you are an honorable judge, lawyers may have a lot to tell you. Therefore, I would say that consciously in my judgments, or in our judgments, we used to refrain from using words like I, we. It is not that I hold or we hold. I tended to write, this court holds, or this court decides. It's a neutral situation. Either I'm sitting singly or I'm sitting. And as far as the district judiciary is concerned, I probably never use the word lower judiciary. I use the learned trial court, the learned first appellate court, or the district judiciary, or the learned district judge. So there is always I would say that we must recognize the intellectual sovereignty of all who are in the profession, be it lawyers, be it judges. You cannot say that some gentleman, he may have thought wrongly, he may have thought incorrectly,
Right, sir.
but that does not give somebody who is superior in the hierarchy to pass a judgment connected to that.
Right, sir.
These are certain unwritten rules or conventions which add a kind of smoothness to the
Right, sir. So you have been in this profession for so long, sir. And if you want to mention any of the practices that were prevalent back maybe 15, 20 years back, but not anymore in practice. So is there anything you can mention which is not, which has been discontinued, or you feel like which maybe could have, for the benefit of the profession, could be kept intact? If there is anything, sir.
I would definitely say that the quality of pleadings before courts requires to be improved vastly. You see, I do not know, there was a book, Experiments in Advocacy, written by the leading advocate, Mr. Dr. Kailash Nath Kartju of Allahabad.
Right, sir.
I think he was the grandfather of the Honorable Supreme Court Judge, Mr. Martin. So it is not, I think the book, I read that book quite some years back. There is an expression that the pleading should conform to the law, not the law to the pleadings. Now there, I have heard, of course, and I have possibly seen, there are advocates, there were advocates at the district court level who could draft a civil plaint in just 2.5 pages. But today, because of, I think, various factors, the quality of both written and oral pleadings, which we at least had an opportunity to witness in our junior days, needs a shine, which means that actually even the prayers that are pleaded need to be understood in their proper context. And that is where it is very important. That is why sometimes as judges, we tend to look at the annexures first. Because we know in pleadings, maybe so much will be said, which is not pertaining to what is germane to the matter. So ignore the green pages, or now the white pages. Come back to the white pages if you are required to, because those paragraphs required to be confirmed by the annexures. So look at the annexures first and try to find out what is the real substance of the dispute.
Right, sir. So if anything you would like to change in the current legal system, if something is being done, if you want to change something which you think can be better or can be done in a different manner.
There is one aspect of the matter that, you see, as far as constitutional writ proceedings are concerned, constitutional court, they take a lot of time of constitutional courts.
Yes, sir.
So, but actually judges are hard pressed.
Right, sir.
And there's a huge queue of cases to be heard out. So like the civil procedure court, where not all appeals are admitted.
Yes, sir.
I think our High Court also, we would need a bench, maybe 1 or 2 benches, where you need to filter based on the synopsis as they have it in the Supreme Court. There is admission of SLPs.
Right.
I think we need to have a system where you need to put all these writ petitions through a filter of 2 judges, where they will decide whether this is fit to go through for further orders or not. For whether then that particular petition can be earmarked to a particular bench. Then that will be difficult for lawyers, but they will have to prove they will really have to prove the worth of their petitions. And if at the filtration stage, like in the Supreme Court, you have Friday and Monday as a miscellaneous day, where petitions are read and then SLPs are admitted, or I think we need a bench of, say, 2 senior judges or more than 2 senior judges who will filter the writ petitions which are filed, or irrespective of category, and decide whether they can go through for further hearing. But I do not know how much lawyers will. There may be the pros and cons to this aspect, but it is the only way one can eliminate unnecessary, avoidable litigation.
Right. So now I would like you to show something, if like an object or a memoir, if you have.
I have kept one preserved for this interview, Sagar. You had told me earlier, I had picked one. This is a medal
Oh my God. Yes, sir.
given to my grandfather from Calcutta University in 1937.
If you can show the camera, sir.
It's a gold medal
Right, sir.
for the Bachelor of Law examination.
So if you can mention his name.
Subrata Talukdar. It says as much. You can show it to the
So
camera.
we will zoom and we will show
You
you.
can show it to the camera. It says much. It's from the University of Calcutta, 1937, Bachelor of Law. This is a family heirloom. And this I can, when you asked me, I could only preserve this to show. And
So I think for you, your
our
grandfather-
beginning in the legal profession was maybe from this medal.
So your grandfather has been a very important part of your legal
Yes,
career.
he was not alive when I joined this legal profession. But then, interestingly, we shared a lot of common backgrounds. Like he came from. What I've heard is that for the school leaving examinations, he was the topper in English in the school boards, and that also from our native place at Chanshi, Borishal.
Yes.
So from Chanshi High School, I visited that in 2017. Of course, I have not seen that. He came to Calcutta to study in Presidency College. And he did and then law from Calcutta University. So he also was writing for the Hindu then. And then but he did not join the newspaper formally,
Right, sir.
because I think they were offering a salary of ₹75 then. But we needed some more money, maybe he needed, so could not be negotiated on that. And then he used to write articles, and then he topped the Bachelor of Law examination, which I've heard. I've showed you the medal also, and got an direct entry into the judicial service.
Oh, right.
So that is how we started our journey.
Right. So if you can tell us about your post-retirement responsibilities right now and how you are seeing after your retirement.
You see, I retired on 3rd July 2023.
Right, sir.
So, post-retirement, if I may use the word blues, have not really struck me,
Right.
because this large ecosystem of judges, lawyers, everything. My personal phone is always in contact with them. The question is, I share their company virtually.
Right, sir.
Either it's a good morning, or it's some kind of a teaser. So this I'm in touch. Secondly, I've been fortunate that I've been kept occupied with some arbitrations. I've taken a 40-hour training to be a trained mediator, so some mediations. And the Hon'ble bench of the High Court has accommodated, has asked me to consider, and I've said yes, and I am now occupying that position of chairman, the chit fund, one-man chit fund committee. So those responsibilities keep me busy. My granddaughter also has come at the right time when I am retired, so she keeps me busy. I think on the whole, and right now there are, accepting the usual, like my mother's health is not well. Those things are part of every family story. The retirement, I have not had the retirement blues so far. I've taken things as they come.
Right.
And particularly right from my days as a journalist to my days as a lawyer, and like today I'm with you all.
Right, sir.
I love interacting with people.
Right.
Yeah, people. Basically, if you can come with it, I am a people-friendly person,
Right.
and of course, the right people-friendly person, because then I can remain in touch with them
Right.
for a longer time.
Right.
And maybe the wrong people, not is their fault, just that we don't vibe.
Right.
They drop off as you travel the journey.
Right.
So it has been, so far 2 years have gone by. Today exactly July, we are on the 6th,
Right.
3rd July 2025, 2 years ago thing. I am, what can I say? One cannot say I'm good, as they use the word, good with my
Right.
personal, and I'm trying to discharge my responsibilities with an equal sense of responsibility.
So if you can suggest any specific book, any legal book or some textbook or something which has shaped you or has inspired you to the young students or the young professionals.
You see, what is there's an interesting side story to this particular question. I was hearing on the division bench an appeal connected to. I was part of the division bench where appeals connected to the education selection process
Right, sir.
were being argued. There was quite interesting matters. Now, one of the question papers came up for discussion. And in that question paper, there was, I think, if I remember correctly, a poem from Tennyson, which had to be interpreted by the examinee.
Right, sir.
There were an option, and the examinee had to write,
Achha.
"Ki this poem, these two words, or this is what the poet meant."
Achha.
Now, that is, I'm coming to the point that the landed senior counsel arguing for the examining board or thing, I asked him, what do you think would be the essence of the poem? I must tell you, admit that the answer left me far from satisfied. Rather, the boy who was the examinee, his counsel was suggesting a closer answer to the correct answer, according to me. So the point which I'm trying to make is, as Justice, if I remember, Felix Frankfurter's famous word, that as a lawyer, you are a complete package. And not that one author interests me. Of course, there are favorites, like Gabriel Garcia Marquez is, of course, a favorite. His 100 Years of Solitude is one of the best books I have read. Then William Dalrymple is one of my favorites. Amitabh Ghosh would be. A lawyer, I believe, because there has to be a wide ranging of, you need not always read
Right.
legal books, SCCs. You have to do them for a career, for your profession. But your understanding will be deepened if you have a broader interest and you read. And also, I think reading biographies, autobiographies. There's Justice Hidayatullah's My Own Boswell, Experiments with Advocacy by Kailash Nath Karju, H.R. Khanna's autobiography. These all assist in shaping your outlook about the
Right,
court.
sir.
And the difference between juniors and seniors, or a junior becoming a senior, is not the quantity of knowledge, it's the quality of experience.
Right, sir.
So experience, the more you expose yourself to it, it will come from all these sources. And that is why I meant to say that I saw a junior advocate once arguing, and I was very, very impressed with the quality of conversation that, of course, that he carried on in court. And I said, very well, you may not get an interim relief today, but come back on the next day so that I can hear you better. And the reason for doing so largely was possibly I could not grant him any interim relief, but maybe I wanted to hear him again.
Right, sir.
So this quality of conversation,
Right.
the modulation of voice, your presence in court. I have also had the opportunity to work with the legendary Siddhartha Shankar Ray.
Right, sir.
Only one of the cases I used to go to his residence. He used to come in his half trousers, half pants. What an elegant personality. So I also had the good fortune to watch the legendary Arun Prakash Chatterjee in Argo in court. He used to fold one of his legs on one stool and on one chair, and we keep the other in Argo. These are figures which we now only talk about. But these were figures, like suppose we talk about our freedom fighters and all that.
Right, sir.
At least that generation of people I've seen arguing in court, and the formidable presence of those advocates. So the question was, now we have, of course, our senior advocates, but that to re-establish that situation, an advocate is a complete package of a complete personality. From the moment he enters court, he's watched.
Right, sir.
And his demeanor, the way he addresses the court, everything does not happen at one go. It takes time for the perception to evolve, both with judges and with clients.
Right, sir.
And that is the success.
Right, sir.
But apart from this is the thoroughness with which you're prepared.
Right, sir.
Your confidence will ultimately come from that.
Right, sir. Right, sir. So, like every good things, this conversation also will come to an end. Sir, my last two closure questions will be, sir, if 2025 would have been the year when you would have started your legal career or you would have started your journey, will you change anything which you had?
I don't think, Sagar, the basics will change.
Okay, sir.
The manner of functioning would change. Maybe I would consult more of my tablet, more on the online reporting, because I have to keep abreast.
Right, sir.
And in our time, we had limited fundamental judgments. So we had, our senior used to tell us, Bina Pani De, AK, Cry Park, Airports Authority, Olga Teles, Maneka Gandhi. These are certain judgments which were, anytime you had a constitutional writ issue, well, look for natural violations of natural justice there.
Right.
But now things have evolved. They have become wider. The entire scope of rich jurisdiction has become very wide. Contemporary concepts are coming in. So I think I would have had to keep abreast, and possibly my training in law college would have also helped me in keeping abreast.
Right.
And environment law is there. I recently addressed a section of students at Durgapur Law College on law and climate change, where a concept has come in, which I was reading. One of our judges in Bangladesh High Court, Justice Kamal, has floated a concept in a landmark judgment. The river, Bangladesh being a land of rivers, rivers have life, and they must be given legal protection. And but there was an international conference where it says, in company boardrooms, you must have a chair for nature. So these are concepts
Right.
which are evolving, which were not there at our time maybe.
Right.
But this concept that in a boardroom of 12 directors, there will be 11 chairs, and the 12th chair would be for a nature expert.
Right.
So we have a corporate social responsibility angle. There are a lot more tribunals. There's a lot more catching up to do. Therefore, there's another aspect which I would like to make. If I was practicing today, I would think of a niche practice for myself. It's like doctors, where doctors now would say, they say quite, in a humorous sense, that you fell down from a second floor balcony and you went to an orthopedic doctor, so he'll ask you from which floor you fell down.
Nice.
You said second floor. You said, I am a third floor a specialist, not a second. So this is humorously said, but I think for lawyers, if they want to make real progress, money, you name a thing, some niche practice. In our time, we were asked, what are you doing? We should say civil, rate, constitutional, or criminal law. But even in criminal law, so there is a PMLA jurisdiction. In corporate law, there is an NCLT. There is even mediation is becoming a separate legal job. So in order, I think now you as young lawyers would have to carry on with the general trend of practice, but yet plan a niche practice. And environmental law may be a practice. Human rights has so many angles. There is, I think in England, abroad, there is a famous divorce lawyer called Max Clifford.
Okay, sir.
What we have read. So these are all, depending upon the flow of times, you have to specialize, super specialize.
Right, sir. So my last question will be, sir, what do you want your legacy to be? How you want people to remember you?
As a good human being.
So thank you so much for giving me this opportunity, sir. We are extremely grateful, sir.
Thank you, Sagar, and your team for also thinking about me. As I said, that I had very big shoes to fill.
We are grateful, sir.